One of the most common and honestly dangerous things that I hear is this: once I file an EB-1A or NIW petition, I'm safe, even if my H-1B or O-1 expires. And I get why people think that. You've done the hard part, you filed a strong petition. It feels like you're finally protected. But here's the problem. That assumption is wrong. And it usually doesn't hurt people immediately, it hurts them later, when they're trying to actually get their green card, and suddenly everything becomes much harder. So in this video, I want to clarify and explain how EB-1As and NIW petitions actually work, what actually happens if your O-1 or H-1B expires while one is pending, and how to think strategically so you don't create problems for your future self. Let's start with the most important distinction. An EB-1A or an EB-2 NIW is a petition and not a status. It does not give you permission to live or work in the United States. These filings simply say, if everything lines up, later an immigrant visa may be available. And that's it. USCIS does not look whether you are in valid status when deciding whether to approve the petition. So here's the line I want you to remember. Your O-1, H-1B, or L-1 is what keeps you legally in the United States, not your EB-1A or your NIW. Now, this is where people get half of the picture right. O-1s, H-1Bs, and L-1 visas are popular because they allow dual intent. That means you're allowed to stay in the United States and pursue a green card at the same time. So filing an EB-1A or an NIW petition does not violate your status. This is normal. It's legal, it's common. But this is the part that people miss. Dual intent doesn't mean no rules. You still have to maintain your status, follow the terms of your visa, and stay compliant the entire time if you're going to be physically present in the United States. Now, what if your O-1B or H-1B expires while the petition is pending? And this is where some people get caught off guard. If your O-1 or H-1B expires while your EB-1A or NIW is pending, the petition can keep going. USCIS may still approve it, but, and this is critical, you must separately maintain lawful status. If you fall out of status, you could still end up with an approved petition, but you may not be able to adjust your status. You may be forced into consular processing, or you may face delays, denials, or extra scrutiny later on. And this is one of the biggest I wish I'd had known this earlier moments for many people. And here's why this is so dangerous. Status issues don't affect petition approval. They show up later. When you apply for adjustment of status, when you go to a consulate, when a USCIS officer is deciding to issue the green card. That's when someone looks back and says, you had a gap here, or this employment didn't match the approval, or you weren't in status during this period. And that's when green cards get denied, cases get denied, waivers become necessary, or people are suddenly told they need to leave the United States. Another major risk point is international travel. If you leave the US to renew a visa, you're exposing yourself to consular delays, administrative processing, unexpected refusals, or long holds. That's why so many people choose an extension of status inside of the United States instead of traveling. But I want to be clear, there is no one-size-fits-all answer here. The right strategy depends on your status, your petition, your timing, your country of citizenship. Some people assume if USCIS approved my petition, I must be fine, but not necessarily. For example, H-1B holders must work for the sponsoring employer in the approved role. O-1 holders must stay within the approved scope of work. Even small deviations can quietly create problems later on. This is something I tell clients all the time. Just because USCIS didn't catch it now doesn't mean it won't matter later. And this is exactly where strategy matters, because the risk isn't always immediate. If you're dealing with a pending EB-1A or National Interest Waiver and an expiring O-1 or H-1B, this is the kind of scenario that we look at when we do free NIW and EB-1A case evaluations. We're not just checking eligibility, we're looking at timing, status strategy, travel risks, and long-term green card planning. You can request one using the link in the description. One last practical tip that people underestimate: keep everything. Approval notices, I-797s, pay stubs, employment letters. This is especially important if you've been in H-1B status for years. Missing paperwork can cause serious problems later, even if your case is otherwise strong. Understanding how your current visa status and your immigration petition interact is critical, but it's one piece of the puzzle. The next question most people ask is, should I apply now, or would waiting actually help me? And that's exactly what I cover in my next video. In that video, I explain how I help clients decide when moving forward makes sense and when waiting strategically is actually the smarter move. I'll see you in the next one.